Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. I'm still out of town and I am sick, so I'm going to be off the camera for a little bit. I've been a little slower on things, just trying to sleep a lot, especially yesterday, so I'm going to do my best to try to catch up a little bit. Last night we had Blake Lively file a reply in further support of her motion for sanctions against Bryan Freedman. Wayfair had responded to their motion for sanctions, saying basically that Bryan is allowed to defend his client. They also made a list of statements that were made by Blake Lively's team, either her legal team or representatives of some kind, and said basically that Bryan was allowed to respond to this. The opposition filed by Mr. Freedman and the Wayfair defendants does not seriously challenge that Mr. Freedman's repeated extrajudicial statements have targeted Miss Lively's character, credibility, and reputation. As such, those statements presumptively violate New York Rule 3.6 and are sanctionable under this court's February 3rd order. Leaving aside the opposition's repeated ad hominem attacks, Mr. Freedman's primary response is that his press campaign has not necessarily prejudiced the jury pool against Miss Lively. But the consistency and volume of Mr. Freedman's themes challenging Miss Lively's character and credibility have created a situation in which the issue is not whether jurors will remember Mr. Freedman's statements, but whether they can escape them. And I'm sorry, but anytime I see these people complaining about ad hominem attacks, all I can think of is the fact that her husband, who's no longer a party to this lawsuit, had a field day over his belief that Justin Baldoni sued over hurt feelings. The opposition's attempt to blame Mr. Freedman's misconduct on various press statements made on Miss Lively's behalf, like his disingenuous rebranding of his proposal to hold Miss Lively's deposition at Madison Square Garden as a scheduling statement, fall flat. No, listen, the Madison Square Garden thing, we've talked about that a lot. I don't really see how that's supposed to prejudice a jury at all. Like, sure, she didn't like the statement, obviously. It was a little snarky, but, like, dude, this is why people don't relate to you. People are allowed to snark at you. They're allowed to talk about you online. You don't have to use the full force of the federal court system to try to punish them for it. In sum, Mr. Freedman has plainly violated Rule 3.6. He has identified no cognizable justification for his violations, and accordingly, Ms. Lively respectfully requests that her motion be granted in its entirety. Mr. Freedman does not deny, and therefore concedes, that he made each of the statements identified by Miss Lively, and that those statements targeted Miss Lively's credibility, character, and reputation. These statements reflect Mr. Freedman's efforts to publicly paint Miss Lively as one, a liar who is afraid of the truth, and so lacking in credibility that she will look at a scene and say the sky is not blue. Two, arrogant, a bully, and a privileged elite. Okay, well, we've certainly seen that. That almost seems like an objective fact at this point. Three, deserving of the organic backlash against her self-concocted disaster, not the Wayfair smear campaign documented in Discovery. There is no smear campaign documented in Discovery. And four, not credible given her husband's SNL appearance. I mean, they're really hanging on to this SNL thing. And I think everybody would have forgotten about it by now if they wouldn't, just keep putting it in here. Instead, Mr. Freedman argues that the chief failing in Miss Lively's motion is the underlying assumption that any statement that touches on a party's character, credibility, or reputation automatically triggers a substantial likelihood of materially prejudicing an adjudicative proceeding in this matter, and therefore violates Rule 3.6. But this hair-splitting exercise runs directly into the plain language of New York Rule 3.6b, which provides that a statement ordinarily is likely to prejudice materially an adjudicative proceeding if the statement relates to the character, credibility, reputation, or criminal record of a party, or the expected testimony of a party or witness. And then the footnote here, they're harping on this Megyn Kelly interview again, where Megyn Kelly said that the public sees Miss Lively as a bitch, which is not only true, but it was also not said by Bryan Freedman. But now we're moving the goalposts on this a bit because they're saying, well, yeah, true, he didn't say that, but he's ignoring his own statements made during the same podcast. Okay, but you didn't reference his statements made during the podcast. You referenced Megyn's statements made during the podcast. And you're still doing it. Here they write, a sustained public relations campaign attacking the character and credibility of a sexual harassment plaintiff creates an unacceptable risk of tainting the jury pool, particularly given Mr. Freedman's admission that, in these kinds of cases, once someone says something, it becomes fact. She may be a plaintiff in a case where there's a sexual harassment allegation, but that does not actually make her a victim of sexual harassment. My opinion is still that she has unfortunately exploited a system meant to protect victims of sexual harassment, sexual abuse, etc., and she's trying to use that to shield her from criticism and sort of excuse her poor behavior and other ridiculous allegations. Because nobody wants to look at somebody who's making allegations of sexual harassment or misconduct and say, well, you're lying. Nobody wants to do that. But it's already undeniable that the original complaints she made, based on the footage that came out, were at least not 100% truthful. No safe harbor applies to Mr. Freedman's statements, While Mr. Freedman is correct that attorneys are not prohibited from speaking to the press, particularly in high profile cases, such interactions with the press must be conducted within the confines of an attorney's professional ethical obligations. When they talk about the statements that Wayfarer identified, where Miss Lively's counsel or spokespersons had made statements to the press that were extremely aggressive towards the character and reputation of the Wayfarer parties, they say first, Mr. Friedman identifies numerous statements made by a non lawyer spokesperson for Miss Lively and baselessly asserts without any evidence or authority that these were in fact statements made by lawyers euphemistically called spokespersons. So I find that interesting because these people have also said the same thing about the Wayfarer attorneys. In letters to the judge and in their filings, they've said that the Wayfarer parties are definitively the ones to leak stuff, providing no evidence whatsoever. And, common sense would dictate that there were so many other people who could have been the sources of that information. And yet now they want to complain about not offering any evidence. And whether or not they were made by an attorney or by another spokesperson, they were still her official statements given on these legal proceedings. Second, none of the statements Mr. Friedman identifies violate New York Rule 3.6. Many of the statements do not even mention Mr. Baldoni or the Wayfarer defendants. So this is actually so fucking stupid. And we'll look at this table that they attach to this in a second, and I'll show you why that's stupid. So the rest of this is just parroting more of the same from their original motion, so I'm not going to really worry about that too much. So here's this table of their statements where they're trying to say basically there was no mention of Justin here. There was no mention of the Wayfarer defendants here, and it's stupid as hell. So they have a category here that says whether or not it's an attorney statement, which, like I said, whether an attorney made the statement or not, could have been a publicist, could have been someone else. It was still her official spokesperson giving her official response to legal proceedings. I can't tell you how that's going to play out in court, but I can tell you from a public opinion standpoint that this is going to seem like kind of bullshit. It once again makes her look extremely privileged, entitled, and hypocritical, even. So, for example, hear this statement. Lively's legal team released a statement to E! News that this is not a feud arising from creative differences or a he said, she said situation. Sexual harassment and retaliation are illegal in every workplace and in every industry. A classic tactic to distract from allegations of this type of misconduct is to blame the victim by suggesting that they invited the conduct, brought it on themselves, misunderstood the intentions, or even lied. Another classic tactic is to reverse the victim and the offender and suggest that the offender is actually the victim. These concepts normalize and trivialize allegations of serious misconduct. Part of their argument here is that there's no mention of Justin or the Wayfarer defendants here, and that's ridiculous. They're obviously talking about Justin and the Wayfarer defendants. So while it's clear who you're talking about, and you're suggesting that they are reversing victim and offender, they say there's no attack on credibility, character, reputation, but clearly there is, in my opinion. These are statements made to the public, meant to shape public opinion, and they clearly paint the Wayfarer parties in a bad light. This one is even dumber, because they're using this quote, "What is Bryan Freedman hiding? After promising to release all the receipts, Freedman ran into court to keep secret the phone records of who Baldoni, Heath, Sarowitz, Nathan, Wallace, and Abel were calling during their retaliatory campaign." And then over here they say no mention of Mr. Baldoni or any Wayfarer defendant. Bitch, all of the Wayfarer defendants are here. Almost all of them. What are you talking about? And this statement was also extremely misleading. This wasn't evidence related to what happened on the film set, and Blake Lively and her attorneys went to the judge and told him to stop Bryan Freedman from releasing this stuff to the press. So they went to go and make sure that he couldn't publish all this information, and then said, why is he hiding? Alright, like I said, I'm not going to go through all that line by line, but it is available publicly on Court Listener. Hopefully I'll start to sound a little better soon. Like I said, I'm still sick, so I'll try to keep up as much as I can over the next couple days. We'll see how it goes. Thanks everybody for watching, and I'll see you all soon.